do you do a great opening statement in a jury trial? Well, there are a lot of different ways strategically to do an opening statement. But the one thing that every great opening statement has in common is that it has an emotional hook. Right or wrong, jurors as people make their decisions largely based on emotion. Now, I know we want them to base it on reason, and we want them to base it on evidence, and that'll come into play. But the reality is, as humans, we typically make our decisions based on emotion. So we need to understand that as attorneys, and we need to make sure that we provide that emotional hook. And so you say, well, John, where does that emotional hook come from? Well, remember when we talked about theory and theme? Well, that theme, that was your emotional hook. That is how you get the jury to understand your side of the case. So now that we've talked about that a little bit, and theory and theme explains it in a little bit more detail, but now that we've talked about that and you know that you have to have that emotional hook, how do you do an opening? Well, a lot of times, if you've got co-counsel and your co-counsel did voir dire or jury deselection or voir dire, or depending on where you're at, and I know people are hearing this from all over, but when they're doing jury deselection, they will have introduced themselves and they may have introduced you. If you've already been introduced to the jury, then don't waste your time with the formality of, well, ladies and gentlemen of the jury, I'm John Collins. I am the attorney for the defendant. Don't do that. And if you are going to introduce yourself because co-counsel did not introduce you, then just say, I'm John Collins. I'm Fred's attorney. Don't say you're the attorney for the defense. Don't make it impersonal. This is your client. This is somebody you care about. It's okay to use their first name. It's okay to refer to them as the person that they are. Now, got the introductions out of the way. Now what? A lot of people say, well, tell them why they're here. Well, hell, they know why they're here. The court's already told them why they're here. I say forget that. Let's jump right into that emotion. Let's go ahead and grab them right off the bat. So, I can give you an example. I had a prosecutor that stood up and said, my name is so-and-so. I represent the people. I represent you. And then she went on through her opening. For the emotional hook, mine was very anti-government. So I stood up, and when it was my turn to talk, I just said, she doesn't represent people. She represents the government. I represent people. You get in trouble next week and you call and say, hey, so-and-so, I got accused by the government of doing something wrong. Will you help me? She's going to tell you no. No, I can't help you. I can't even talk to you. You're a defendant. You need to call John Collins because she does not represent people. Bobby's people. Sitting here at my table, he's people. They're the government. Let's not forget that. And then I went into my opening, weaving in the rest of my, this is the government coming after a citizen, because that was the emotional hook that I needed. So once you've established that, once you've gotten past the introductions, once you've gotten through that, this brings up the question of what kind of order do you use? Do you use chronological order? Well, it doesn't have to be chronological. Sometimes chronological order is what you want to go into. But sometimes for that emotional impact, you want to start right where the worst part of the case happened. So, you work for the government, you're a prosecutor, you're doing a murder case. Bam! Shot rung out. Billy fell, still holding his son's hand. That would be an emotional and impactful way to start that opening statement. You don't want to be argumentative in an opening statement, but you may have to go through and talk about some of these things that you believe the evidence will show. Now be careful of saying, well, the evidence will show, and the evidence will show, and the evidence will show, and the evidence will show. Because this is a conversation. Remember, you are talking to the jury. You're not just talking at them. You want them to hear you. You want them to feel you. And you're going to lose them if you just keep repeating the same phrase over and over and over. What else should come out in an opening? Well, frequently the burden of proof. And that's from a defense side or from a plaintiff's or prosecutor's side. We need to talk about what the burden is, because the jury does need to understand that. And you'll get another chance in closing, and the judge will also talk about it, but you need to make sure that you get that in there. You also need to finish it up by telling the jury what you want. And it doesn't have to be, I want this person found guilty. I want this person found not guilty. I want you to give us $1 million. I want you to tell them to go pound sand. You don't have to be quite so direct, but you do need to let them know, hey, there are sides here, and I'm going to ask you to jump on our side. Sometimes our side is just locking arms, singing Kumbaya, and telling the government to prove it. But you need them to understand that there are going to be some sides. Now, what I like to do in all of my openings is I tell the jurors to take notes. And when I'm doing an opening, because I am on the defense, I relate it directly to what the prosecution said. Now, I don't counterpoint them. That's not it. But if they say, we're going to prove this, 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 and this, what I tell them is that they're going to get instructions from the judge. And they heard the prosecutor say, we're going to prove this, 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 and this. Write down whether or not you think they proved it. Write down whether or not you have questions about it. And then if they don't answer those questions, have they met their burden? Write down those questions, because questions are important, because I want them to really put the government to task on what the government said they would prove. Because if they don't prove any part of it, then the jury's going to feel like they just couldn't, or that they had been lied to. So you want to make sure that if you're in that position and you're saying the evidence will show this, or we expect the evidence to show this, that you end up showing that. And that's why you have to be really, really careful. And you have to be particularly careful when you say, you will see evidence that. If that evidence has not been stipulated to, then you may not get it in. And if you say, you'll see evidence that the gun was a semi-automatic, blah, 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 and then the gun can't be introduced, well, that's a problem. Now, I mean, obviously, I know you can tell by other things, but you need to make sure that you don't commit to proving things that you may or may not be able to prove. That is the general rules for doing a great opening statement. If you have questions, just put them in the comments, and I'll see if I can address them. But good luck and have fun in your trials.